there have been two recent court decisions, as well as some Department of Revenue rulings that have made dramatic changes to the application for sales tax exemptions and the collections of taxes on the sales or for resale. To be very candid, what this has done is this has evolved to the point where it has created a need for the legislature to clarify what needs to happen. And so what Senate Bill 928 does is this bill restores the practice of the way that we've been doing business in this state for years. Specifically, this act provides that in general, sales for resale will not be subject to sales tax provided, such that the sale is taxed in this or another state for resale or exempt from tax.
The first one to talk about is probably the more broader and overreaching case, and that is the ICC case. And in that case, what the court decided is that if you're selling something to an exempt or excluded entity because they're not required to pay tax either constitutionally or through some exemption in the statute, that you will pay the tax because they don't. And this includes not only the business community, but you'll also hear from utility industry and also the farming community. So we would like to take that, our legislation will actually hold us harmless and take what we believe is the true intent of the legislature on that issue back to the law existing prior to the Supreme Court case. I know there's a lot of people here, so I don't want to steal their thunder. On the second case, the Music City, this deals with the way that taxes or tickets to places of amusement, recreation, or entertainment is taxed. For decades and historically, those were treated as a gross receipts tax, in which at the first initial sale of that ticket is when you receive that tax. And they're treated differently for many reasons. First, treated differently for many years because the tourism industry has a reason to actually want those revenues to stay local. So by treating them as a gross receipts tax, you're actually taxing them at that first initial sale. You'll either tax them then or you'll tax them at the final sale. If you tax them at the final sale, which is what the court has decided, that it's not taxed at the initial sale, that there's resales, and then if you tax them at that final sale, many of those final sales will actually be sold out of state. So the tourism money will then be diverted out of state. And so we think it's very important that we revert this back to the legislation or the intent of the legislature before the Supreme Court case.
The Missouri Rural Electric Cooperatives are nonprofit organizations, and we serve approximately 650,000 member customers throughout the state of Missouri, primarily in rural areas. We do this by way of a kind of unusual operating system. We call it the three-tiered system that is comprised of 40 distribution cooperatives at the local level. These are the ones that actually provide service to the customer, and 7 regional generation and transmission cooperatives. When the ICC decision first came down, that was the first court case that Tracy talked about, we got to work to see what kind of impact that would have on the co-op system. I mean, we knew that we sell electric power to a number of either excluded or exempt customers, agricultural customers, water and sewer districts, jails, schools, other municipalities we sell power to. So we knew this was going to have a definite impact since we'd been using the reseller exception in providing this service. The ICC court tells us that we cannot collect that tax from these exempt customers, but we are now going to have to start paying the tax. We'll have to absorb it. And without getting into all the rate-making aspects of it, we basically take that additional cost, put it in the pot, and distribute it out to all of our customers. So we've been looking to try to quantify the impact on this. We're still in the process of doing that, but I can tell you from what I've seen thus far, the adverse impact is somewhere between very significant and devastating. We understand that several of the interested parties in this bill may be working on some additional language for the bill to tweak it a little bit. This is a very complicated area, but as the bill stands right now, the rural electric cooperatives support it, and we are going to be working with the other parties to, if there are any needed changes, to try to support that. One last thing I'll say is the urgency of this matter. Our co-op systems have already received notice from the Department of Revenue that they are starting to implement this court decision. So, frankly, we need this fixed as quickly as possible.